now suing the DOJ for $100 million in damages. It should be like $1 billion easily. The FBI should have sought a consent to search the premises before resorting to a search warrant, right? Just ask. Could have just asked. We track down through cell phone analysis and we arrest, okay, like everything. Like, go get that guy, like he's a PDF file or something like that. No, somebody walking through the Capitol after the cops tap people on the shoulder and let them in. Trump now set to sue the DOJ and the FBI for raiding Mar-a-Lago unconstitutionally, illegally, with Jack Smith unlawfully appointed, stealing money, appropriating stuff from a slush fund at the DOJ to fund the whole thing. Case dismissed. Trump wants compensation, restitution for this raid. They also took pictures of Melania's bedroom and Barron's bedroom, gobbled up a bunch of documents. And what is all of that about? Maybe this lawsuit will tell us. But here's some background on what happened. So Trump is now suing, or will be suing. This is a notice of claim. It's very complicated to sue the government because they put up a bunch of speed bumps and roadblocks to prevent you from doing that. But here's what Trump says. Now suing the DOJ for $100 million in damages. It should be like $1 billion easily. The political damage alone was $1 billion easy. Now, Fox News got the memo. Trump and his legal team say that they intend to sue the Justice Department. They file a notice of claim and they try to settle it there, but then they don't. We intend to sue the DOJ. After the raid, Jack Smith was appointed to investigate after the raid, but he inherited the entire team. Okay, they're all part of this corrupt ordeal. Smith ultimately brought 37 felony counts, every one of them dismissed, including willful retention of national defense information, conspiracy to obstruct justice, and false statements. Trump pleaded not guilty to all counts. But then U.S. District Judge Eileen Cannon last month dismissed Smith's case against Trump altogether. Gone. Cannon ruled that Smith was unlawfully appointed and illegally funded, citing the appointments clause in the Constitution. Sorry, Jack. So then Trump's attorney, Daniel Epstein, filed a notice to sue the DOJ. They've got 180 days from now, from the date of the receipt, to respond to the notice. Trump's case will move forward in the Southern District of Florida. Now, what Trump is doing here is not just standing up for himself. He's standing up for all Americans who believe in the rule of law and believe that you should hold the government accountable when it wrongs you. Said Trump's attorney, there's a beautiful property that was raided by plainclothed FBI officers carrying weapons that had a use of force policy that authorized them to shoot and kill. If necessary, they could have done it. And they didn't have to, fortunately, but why'd they raid with guns and in plain clothes? So here is Trump's notice of claim. This is going against the U.S. Department of Justice brought by President Donald Trump. Going forward, saying this is a claim brought by Trump. Here's the date of the accident or the injury that occurred, which was the raid of Trump's residence, 8:39 in the morning. Now, the FBI special agent in charge was a witness, Derek Piper there, assistant special agent in charge from the FBI. See the memo for a bunch of other items. Insurance not relevant to the claims. Deductibles not relevant to the claims. Trump will pay for the damages there, whatever, but we're not going to be invoking insurance. We would just want compensation. So here, this is the form for making a claim and recovering damages against the United States. This goes over to the Department of Justice, Federal Tort Claims Section, to Chetan Patel from Trump's defense, and in this case, his plaintiff's team. They say, all right, DOJ and government, this memo is letting you know that we're about to sue you for tortious conduct under Florida law. Now, the tortious acts, which are the violative acts against Trump, are rooted in intrusion upon seclusion, malicious prosecution, and abuse of process resulting from the August 8th raid of his family's home. This case falls within the established exceptions to the practice of the United States not generally waiving sovereign immunity for this. Here's why. First, a clear exception to the intentional tort bar exists. And second, this carve-out, we're allowed to bring this claim. Here's why. Now, as explained below, the operational level decisions here were made by Attorney General Merrick Garland and FBI Director Wray. Those decisions were inconsistent with other protocols requiring the consent of the investigative target, that's Trump, and disclosure to Trump's attorneys and the use of the local U.S. Attorney's Office. The two at the top didn't do any of those things. And further, Garland from the DOJ and FBI Wray, their decisions about the Mar-a-Lago raid were not grounded in any social, economic, or political policy, but they were in clear dereliction of their constitutional duties. They applied inconsistent standards to Trump, and there was a clear intent to engage in political prosecution. Now, not to advance good law enforcement practices, and that's why we're filing this claim. Now, the actions by Garland and Wray were not discretionary, but they were required as a matter of procedure under the Constitution. They do not have the authority to deviate from these protocols. Garland and Wray should have never approved a raid and subsequent indictment of President Trump because the well-established protocol with U.S. presidents was to use non-enforcement means to obtain records. But notwithstanding the fact that the raid should have never occurred, Garland and Wray DOJ should have ensured their agents sought consent from Trump, notified his lawyers, sought cooperation. Instead, Garland and Wray decided to stray from the protocol, and they did it intentionally to injure Trump. Now, under Florida law, there's a claim called intrusion upon seclusion. So we're not in criminal land anymore. We're not talking about crimes. We're talking about torts. These are civil offenses that still cause injury to somebody, but it's not criminal per se. And here we're suing the government to recover damages from this claim, which is an intrusion upon seclusion. So they say under Florida law, there is a concept called intrusion upon seclusion. It's an invasion of privacy right. Somebody invades your privacy, you sue them. Now, an intentional intrusion, this is what it's required, physically or otherwise into the private quarters of another person. So those are the elements, right? We talk about the checkboxes of an offense here, or elements of an offense. An intentional intrusion, physically or otherwise, into the private quarters of another person. And the intrusion must occur in a manner that a reasonable person would find highly offensive. I do. We were outraged that they went in there and took photos of Melania's bedroom. Why? Why did they need to go in there? Were there documents in there? No. Were there any evidence of documents being in there? No. Why'd they have to go into her closet? I don't know. Now, the first factor requires an intrusion. The second factor is one that's so severe and unacceptable that a reasonable person, you or me, would be offended by it. Now, the former assistant director in charge of the FBI, he testified that based on his over 20-year tenure at the FBI should have sought a consent to search the premises before resorting to a search warrant, right? Just ask. Could have just asked. Additionally, Mr. D'Antonio, 20 years, testified that the FBI refused to wait for President Trump's attorney to even be present before starting the raid. Wow, shocking. Now, protocol would require both of those things. Mr. D'Antonio testified that the FBI sought to exclude Trump's attorney from the raid, which was a move with which Mr. Antonio disagreed. He also believed that the FBI should have worked with the president's attorney to get a consent search before a search warrant. They didn't want that. They wanted a raid. Mr. D'Antonio's testimony is consistent with internal emails that we'll look at to the DOJ and FBI officials a week before the raid, where the FBI Washington field office team requested that the DOJ and the FBI get cooperation from the president. Can you just get cooperation from him to search from any documents, stating that a consensual search would provide a level of comfort that the FBI has gotten all the documents back, okay? But FBI officials in the emails, they refused to seek such consent. They wanted a raid. Now, the primary allegations here allege intentional injury to President Trump. Trump nevertheless preserves his ability to claim negligence to the extent that law enforcement officers were subject to negligent instruction by Wray. So maybe not even blaming the field officers, the field agents, blaming the directors. The facts may support a negligence claim that would not permit AG Garland or Director Wray to claim is a matter of unreviewable discretion. In Florida, negligence results if defendants had a duty to use local agents rather than DC agents and failed to seek Trump's consent. This is a breach of a DOJ duty and it caused injury to Trump. And so all of that, they're saying we're just preserving our right to make additional claims. Now, FBI demonstrated activity and it was inconsistent with protocols used in routine searches. Trump had a clear expectation of privacy. It was his home. His family lived there. And the raid where the established protocol was violated constitutes an unacceptable intrusion to anybody who's a reasonable person. Now, that was just one claim, okay? They violated his right to privacy. Similarly, there was also malicious prosecution. They had a vendetta to go take Trump out. Malicious prosecution is another type of tort in Florida. It requires the following elements. There are 6 of them. So think about these as checkboxes. There was an original criminal proceeding that was commenced against Trump, okay? The present defendant was the legal cause of the original proceeding against the plaintiff. So Jack Smith is the prosecutor. He's now the defendant, essentially. The DOJ is the one who prosecuted Trump maliciously. Okay, got that. The termination of the original proceeding was a termination in favor of Trump. Got that one. Okay, 3 for 3. There was an absence of probable cause for the original proceeding. Boom, 4 for 4. And there was malice on part of Jack Smith and Merrick Garland. Got that too. The plaintiff suffered damage, yes he did, as a result of the original proceeding. Boom, we're 6 for 6 on that one. Looks good. So Jack's office, obviously, the entire case was based substantially on the fruits of a search warrant. Remember that? We covered that August 8th. They brought a lawless criminal indictment against Trump on July 27th. Now, the United States was the cause of this proceeding, which was dismissed by Eileen Cannon on July 15th. Sorry, Jack. The defects of the appointment of and the appropriations for Jack Smith and the overbreadth of the search warrant shows there was no probable cause leading to this indictment. In fact, look at this law professor called John Yoo, former senior DOJ official here. He says this, John Yoo, he's a professor for Berkeley. He writes, "We've never indicted a former president before." And so that itself is a major hurdle. That's a major statement to say that we have probable cause. You know, we, the government, have probable cause to believe that Trump has committed a federal crime. And then the second thing is, if you look at the search warrant, the same thing I think is really important is the breadth of it. It essentially says you, the FBI, can look in Trump's home for any document at all that was created by President President Trump in the time period of the presidency. We read through that too and thought, oh my gosh. So it actually goes well beyond just searching for classified information. And so that's what causes, I think, a lot of the controversy over it is, one, was this necessary, putting aside whether it's constitutional or not? And I think, and we can get into that, but when was it necessary? And then two, why the breadth? Why look for a lot more than just classified info? Because this was political hit. Now, moreover, as the Court of Appeals and Merrick Garland should have foreseen, Trump had immunity from prosecution like all the other presidents did. Now, as such, given the Supreme Court's immunity decision and Cannon's dismissal on the grounds that Jack Smith was illegal, there was no constitutional basis for the search or the indictment at all. Now, this is where it gets good. Internal FBI communications reflect the skeptical attitude of line-level agents to the probable cause theory. Why should we rate him? There is no basis for it at all. Documents obtained from the FBI and reported in Bloomberg reveal the bias, we call them political antics, and lack of probable cause involved in the raid of Mar-a-Lago. Here is one email. This one came out from this person, Chansonette, guessing it's a she, from Chansonette Mori at the FBI. Subject, search warrant on former President Trump. She emails this to Paul Abate. We know who he is. We see his name all over this stuff. He's a real piece of something. So Chansonette says, good morning, sir. Just wanted you to be aware of the concerns and comments our office has received regarding the search of former President Trump. Here's one. Hello, Chansonette. Did this really just happen? Am I dreaming? So Chansonette looks like she is the acting ombudsman. So she's, you know, what's the water cooler talk look like? Someone sent this to her. She's forwarding it along to Paul Abate. Did this really just happen? Am I dreaming? Says somebody at the FBI. The FBI served a search warrant on a former president. The news is redacted, saying it's about documents. Did this really just happen? I've lost just about all faith in our leadership. Obviously, they forgot Crossfire Hurricane, where they made up a bunch of stuff about Trump. If he took documents, give him a call. Ask for them back. Like, seriously? My own agency? A bunch of Democrat political hacks up top. Amen to that. I don't know how many blank, 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 but they may have lost one here, right? I don't know how many people they're trying to recruit for these positions, but they may have lost me. Is there any plan from leadership to explain these absurd actions? I no longer believe we have real probable cause based on Crossfire Hurricane. In other words, they've already been caught faking investigations into Trump and everything else I've seen to include targeting parents based on the AG's letter. Now they need to explain their embarrassment of the Bureau. That used to be a mortal sin. Please convey this message. They owe our workforce an explanation of their overt political antics, which is clearly what they were from the beginning. Another FBI agent, or continues, thanks. Also, Chansonette, while you're at it, please ask them why we break out all the tools to enforce a federal misdemeanor of someone walking through the Capitol on January 6th. We track down through cell phone analysis and we arrest, okay, like everything, like go get that guy, like he's a PDF file or something like that. No, somebody walking through the Capitol after the cops tap people on the shoulder and let them in. But people can violate 18 U.S. Code 1507 every single day and harass Supreme Court justices in broad daylight on the news and nothing is done about it. Why? Well, because it's a hack agency, that's why. I believe they won't be able to answer because the answer is that they are a bunch of political hacks of the Democratic Party. Federal law is quite clear. Under 18 U.S. Code 1507, it is a criminal violation of federal law to picket or parade near a building or a residence occupied by a federal judge, juror, witness with the intent of interfering with or impeding the administration of justice with the intent of influencing the judge, clearly they are with their signs, in the discharge of his duty. Okay, so these are other people from the DOJ, looks like from the FBI in this one, who are sending letters in to their superiors. In another email, an agent questions whether there was a prediction for the raid, as well as questions about the existence of probable cause for the warrant, suspecting the motive was any type of political opposition. So here's another one. Good morning, says the ombudsman to Paul Abate. Here's what else we're hearing. Hello, Chansonette. See the start of the result below from the politicizing and absolute embarrassment of the recently formed Banana Republic Bureau. Wow. People are threatening us more than usual due to the actions of a few. Here we go again. I can't wait to see what training we will have to all do now as a result of this. More training we have to do because you raided him. What is the prediction of the investigation involving the search? It better be more than putting a few documents in the archives or classified material of which the man could have declassified. What is the probable cause of the warrant? It better not involve any type of political opposition. Provided 1 and 2 are legit, they weren't. Why didn't someone work with one of the delegates to resolve the problem? I doubt it was the least intrusive method, and they probably wanted the publicity. The 7th floor needs to lead and provide faith back in our organization if it's even possible. It's not. It isn't. Now, additional FBI communications also reflect internal concerns with the DOJ's expressed bias that was likely to negatively affect the raid. In emails received by the field office officials, Anthony Riedlinger and Stephen Duantuano, their concerns were raised reflecting the DOJ's disinterest in following the standard procedures. We're not going to follow our normal routine routine. Why would we? Here's some excerpt. It tells us this came from an internal FBI email from August 4th before the raid. It says, okay, since we heard the National Security Division say yesterday in the call that, quote, this guy said, he frankly doesn't give a damn about the optics, right? We don't care. Raid him. We hate Trump. We're psychopaths, so just raid him. It's going to wreck him, the 234 years of historical precedent, but that's okay. And Jay Bratt, they already built an antagonistic relationship with Trump's attorneys. I think it's more than fair to say that the DOJ contact Trump's lawyer just prior to the warrant. It's not going to go well. The DOJ said as much yesterday. I also think it's fair to say that if the FBI calls, having in mind officer safety, the optics of the search, and the desire to conduct this search in a professional and low-key manner, there's a far better chance the execution will go more smoothly. We may actually gain some measure of cooperation, which would go some way to resolving the mishandling of the records in the first place. I understand that this request may not go well at the DOJ, but it's the FBI doing the warrant, and we have to deal with this. DOJ doesn't care. Like, go raid him. We're going to take him out, so just get ready for it. Now, Garland, Ray, and Jack Smith has been a malicious prosecution. Even the FBI agents are like, we shouldn't have done that. The malicious prosecution led Trump to spend tens of millions of dollars defending this case and his reputation. It's been an insane amount of money that he's been having to spend. The amount has been ridiculous. Now, also, it's an abusive process. In Florida, the elements required to establish an abusive process claim are also here. Illegal, improper motive, an ulterior motive to benefit Jack Smith and the government and Biden and Harris, and damage the plaintiff because of what they're doing. They want to strip him of his money. Now, as the factual recitations above show, the process used against Trump was unconstitutional and aimed at politically persecuting Trump, which led to extensive costs. In Cannon's decision, she describes the ulterior motives behind Jack's appointment. Said Attorney General Reno, who created the Reno regulations that they used to say that Jack Smith was a real boy, even though he's not, observed that the act distorted the process of prosecutorial discretion by creating a new categories of prosecutors with no limits on their budgets, artificially incentivizing prosecution, saying that all of this created limitless prosecutors. And it turned out that's exactly why they wanted it. Now, Judge Cannon also opined, she says, there does appear to be a tradition of appointing special attorney-like figures in different moments, but here the process was clearly misused. There was a lack of appropriations, there was a lack of a constitutional appointment, and the unconstitutional nature of prosecuting Trump, who is immune, shows how misused this was. Now, also, the justification from Jack's office for prosecuting Trump, very different than how they treated Joe Biden. As vice president, also retained documents as personal property. Trump had a good faith belief that he was entitled to those documents. And furthermore, consider the almost 5 years after Obama's presidency ended, his representatives discovered another set of boxes, okay? Obama sent his records 5 years back. Before the Obama presidency, the DOJ defended when people were trying to come and get Clinton's records in his personal sock drawer. Remember, Judicial Watch, shout out to those people, tried to sue Bill Clinton and the DC Circuit. They're his documents. You can't come after those. They're his. Ordering the recovery of the records was deemed inappropriate. Federal courts can't deal with it. And Jack Smith said, that's fine, we'll do it. But for Trump, the DOJ flipped its position for the first time in its entire history. Everybody else could do whatever they wanted with their documents. Clinton can delete them on a server in the basement. They use law enforcement here. The DOJ's mistreatment of Trump is inconsistent with the executive branch practice going back to Carter. And yet after his presidency, Carter's presidency, Carter found classified materials at his home. 40 years! President Clinton nor Carter were subject to the raid of their residences, and Trump's home was searched for records without any overture from the government. No one even tried to negotiate with him on those, unlike Obama and Biden, who retained those without any legal consequence at all. And why would the National Archives and the Records Administration negotiate with Trump when former National Archivist David Ferrero was at all times biased against the president, stating, it's important to me that the Biden administration replace me. I'm concerned about what's going to happen in 2024. So that guy needed to go. Now, the investigation and the prosecution of Trump, so starkly different than the DOJ's other standard operating procedures, is all part of a political scheme. No procedure in the DOJ justifies the use of their power in this way. Now, in Florida, Trump is demanding compensatory damages. They're awarded to a plaintiff, in this case Trump, for actual harm suffered. The DOJ and the malicious prosecution caused Trump at least $15 million in actual harm due to his legal costs. And that's just scratching the surface. Florida law recognizes that a malicious prosecution action is actionable per se on its face. Thus, certain damages are assumed to follow from the wrongful prosecution. Now, there's also punitive damages, baby! The intrusion into Trump's seclusion, the abuse by Garland and Ray, and the malicious prosecution are egregious. They show malicious intent. The fact that several FBI employees and the former assistant director in charge viewed the raid as oppressive and politically biased, other agents in the agency are like, yo, this is a problem. That shows this is an egregious abuse of process. Also, Cannon's dismissal, saying that Jack Smith was not a real boy, shows this was overtly malicious. She revealed the extent to which the legal malice occurred. She said the bottom line is this: you can't have Jack Smith usurping the powers that are dictated in the Constitution. He did so illegally, and the case was dismissed. And so Trump, in his notice of claim, says, for these harms to President Trump, the respondents, Jack Smith, DOJ, FBI, right, however this is going to end up, must pay punitive damages of $100 million. And that's like nothing, okay? That's like 1/10 of the damage. Here in a footnote, President Trump faced legal costs of over $60 million per year shortly after he left office. And that's about what we were thinking. Remember, because we were thinking it was about 12 to 15 a year in government funds. And so I think we were saying 3 to 5 times that. So if the government spends 15 million, Trump's got to spend 4 times that, 60 million. So, wow, yeah, that sounds about right, because the government has their entire staff all on staff, right? They've got everybody, they just pay all automatically. So Trump has to go stand up on an entire team. And it's not to mention the political damage that this has caused. Billions of dollars. Trump stole documents, nuclear secrets, Jack Smith's legitimate, and Merrick Garland's not a political hack, and Joe Biden's competent and all this stuff. No, it was a political raid to take out a political opponent in America, and half the country cheered it on like maniacs. And so Trump is filing his claim. To be honest, I'm not optimistic that he's going to get $115 million back, but he should. He should get $1 billion back from the government for what they did. We'll see if he does.